So, to this person on the device just labeled Mac, would you be Stephen Smith?
My Christian appellate name is capital S, lowercase Tepehen, capital S, lowercase Mith.
Okay, so that would be a yes. Thank you. Deputy Sims. Now calling 24W003208A, the Township of Ypsilanti versus Stephen Cameron Nigel Smith. Deputy Sims, state your name for the record.
Deputy Sims.
Thank you. Okay, and Mr. Smith, you've already stated and spelled your name out. Thank you. Today is the date and time set for an informal hearing in this matter. What I have is a citation issued November 17th, 2024, that charges that on or about that date you did operate a motor vehicle on Holmes Road at or near Ford Boulevard. And when you were pulled over, you failed to disclose to the officer that you had a concealed pistol and a CPL.
That concludes the officer's testimony. The court makes it clear that it cannot act as anyone's trustee. Its role is to remain neutral, serving as a referee to ensure fairness, not as legal counsel or a personal assistant. This argument is sometimes used in an attempt to create a conflict of interest and force a judge to step aside. While it may seem strategic in theory, in practice, it doesn't hold up. Courts recognize this approach and proceed accordingly, keeping the process focused and moving forward.
So, it looks like you were also cited for having a window tint. I don't have that citation, which presumably means that it was paid. So, again, this is a civil infraction. There is no criminal penalty associated with this, no jail time, no probation. There is, however, a fine. Before we get started, Deputy Sims, was there anything that you wanted to say?
No, ma'am, I'm ready to proceed.
Mr. Smith, as you have likely heard already, you have three basic options when it comes to this citation. And these are your three options. You can accept responsibility, that is basically admit that you did not disclose per MCL 28.425F that you had a license to carry a concealed pistol and that you did not present that immediately to the peace officer when you were pulled over. You can accept responsibility with an explanation, so the court can take into consideration any mitigating factors and potentially lessen or eliminate the fine. Finally, you can deny responsibility, that is, deny that you failed to disclose your CPL immediately, at which point we will proceed to the informal hearing. I will swear in both sides, take testimony, and make a decision based on preponderance of the evidence. Which of those three options are you going with?
I want to, may I grant my name to the court and make the court trustee?
That wraps up the officer's testimony, which is fairly clear-cut. The defendant was pulled over and failed to disclose his CPL while carrying a concealed firearm, an apparent violation of MCL section 28.425B, which requires disclosure during a traffic stop. Under normal circumstances, a trained lawyer could mount a reasoned defense, examining legal nuances and mitigating factors. But here, we're about to see how someone representing themselves without proper legal strategy handles the situation.
But the option 3, as your question, I deny responsibility and I have an explanation.
Okay, so if you are denying responsibility, then I'm going to swear you in and swear in the deputy, and I will take testimony from both sides. So let me explain how this is going to work. After I have sworn you both in, I am going to take testimony from Deputy Sims first, because Deputy Sims is the officer in charge of issuing the citation. That means he's basically the plaintiff in this matter, okay? Once he has finished his testimony, which you are not to interrupt, it will be your turn to testify. He is not to interrupt you either. After I've heard the testimony from both sides, I will make a decision based on preponderance of the evidence. As I stated before, that is a 49% to 51% standard. So basically, whoever's testimony is slightly more persuasive. This is not a criminal case. It is not beyond a reasonable doubt in this situation. So, do you understand? Do you comprehend everything that I just said?
I do comprehend.
Thank you. Okay, raise your right hand, Deputy Sims, and Mr. Smith, you will have to tell me when it's raised if you're not turning your camera on.
It's raised.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth to the best of your information, knowledge, and belief, Deputy Sims?
I do.
Mr. Smith?
Yes.
Thank you. Okay. Deputy Sims, you may proceed with your testimony.
On 11/17/2024, about 3 a.m., my partner and I observed a black Ford Fusion. It was on Ford Boulevard. I believe it had just turned onto Ford Boulevard with tinted windows. Proceeded after the car. It turned into the gas station there on the corner, and we followed it into the gas station and proceeded towards one of the exits. Before it returned to the road, the driver, Mr. Smith, exited and began yelling at us. At that point in time, we activated our emergency lights and conducted the traffic stop there. We made contact with him, explained the reason that we had followed behind him. And when I approached the vehicle, I looked in the vehicle and I observed a firearm on the passenger seat. At no point in time during that did I hear I have a CPL until after the firearm was located. He was detained. The CPL was verified. He was issued the citations and released.
The traffic stop began because the officer noticed an illegal tint on the front windshield, which is a legitimate reason under the law. While the defendant later suggests the stop was racially motivated, the facts tell a different story. If the tint violation was present, the officer had a clear, lawful reason to initiate the stop. At that point, assumptions about race are irrelevant. The action was based on an observable traffic offense, not personal characteristics.
Mr. Smith, it is your turn.
I want to mention there's no damaged property or victim under sworn oath. Also, I believe I was being racially profiled. I had been pulled over, which I did stop, and I was let go because I wasn't suspected of any crimes, just as I wasn't suspected of any crimes by him as well, as he mentioned. We had sat in the intersection, which I was in the middle of a DoorDash, and I wanted to get on my phone to see where I was at. When I looked away from my phone, I seen him, the officer, and another deputy, or whoever it may have been, an officer, also sitting in the middle intersection for about 30 seconds, maybe to even 60 seconds. So he could see me through my windshield. While I believe it was racial profiling, considering the area we were in, it wasn't the best area. So when I pulled, which I did use my turn signal, and it was a stop sign, or it was a light, a signal light. So when the light turned green, I turned right with my turn signal. I also turn signaled into the gas station, which I was going to stop to check my phone, because like I told the officer that had pulled me over 10 minutes before, which I'm sure he heard on the radio call, I was door dashing, which I had admitted to both of the officers. He called another officer in response to what he calls me pulling myself over. He never admitted to pulling me over. He said I pulled myself over. I got out the car to explain myself that I was door dashing and that I felt like I was being harassed because I was just previously pulled over. I did not have a firearm on person, and he didn't have a reason to suspect me of any crimes or try to search my vehicle. I was illegally searched on person without my disclosure. I told them I don't consent to any searches, and they were digging in my pockets. I have a legal license, and I'm not suspected of any crimes. So
In that last segment, there was a mix of a strong point and a weak one. The weak point, claiming the stop was invalid because it depended on the officer's statement. Without audio or video evidence, that argument falls flat. Plus, any amount of illegal tint on the front windshield automatically gives probable cause for a traffic stop in Michigan. The stronger point was questioning whether the tint was actually measured or tested. If unverified, that could challenge the equipment violation. Still, it doesn't excuse the other infractions. Now, the court is prepared to issue a ruling on the equipment ticket.
after he said I pulled myself over, he flashed his lights and they kind of like grabbed me up and I feel like they assaulted me in a way. And after he figured out that I did have a CPL disclosure, which he never gave me time to disclose because it was not on my person. So I didn't feel the need to because I was not present in my motor carrier for him to be in any type of danger. After he sat me in the car, which I feel like I should not have been detained that way, for about 15 minutes, they let me be on my way with a citation. And I don't believe I deserve the citation. And he doesn't have any evidence of the situation. It's just a presumption with no material.
Does that conclude your testimony?
Yes.
And did you have any evidence or witnesses that you wanted to present?
I have evidence on my phone of me asking him, what their badge numbers was, which they didn't really want to disclose. So I had to look it up on the internet. I have a dash cam, but it was not running at the time.
So before we continue, I do want to apologize because I did actually have the equipment violation citation as well. That is for the window tint. So did you wish to address the window tint specifically?
That's just how the car came. I bought it that way, straight from Ford. So it's
Okay.
free.
In Michigan?
Yes.
Deputy Sims, since I don't think I specifically asked you about the tint either because I had misplaced this on my desk, do you wish to address the window tint?
Yes, ma'am. I'm sure you're aware that no vehicle that comes from the factory has front window tint on it. During his first testimony, he admitted to having window tint and said that we saw him through the windshield, which is not possible at night, but he admitted that there was tint.
May I add something?
You may.
There's they didn't test any window tint for any type of darkness issues or anything like that. It was just kind of an excuse because that wasn't the first reason that he told me that he pulled me over. It wasn't for window tint. And you can disclose that through the video of his own body cam. They said that they pulled me over because he presumed that I was trying to turn around in the parking lot or evade him, but I was door dashing like I told the officer that pulled me over before.
So Deputy Sims, I believe when you testified a moment ago, you said you had noticed the window tint. Did you want to respond to that to me, please?
I guess, what are you asking?
You had stated that you initiated the stop, or at least you started to initiate the stop based on observing window tint. Is that correct?
So yeah, I mean, I was with my partner. So there's also the part of he came off of Holmes Road, if I remember correctly, turned right into the parking lot, and then cut through the parking lot to go back onto Holmes Road. It didn't seem like there was any intention of him trying to stop at the store or anything like that. So he's also cutting through the parking lot.
May I add?
You may.
I did not try to cut through the parking lot, as I mentioned before, and prove to the officer before I was door dashing. And if I would have been on my phone, then he would have tried to get me for that as well. So I safely pulled over to where I could view where I was. And it was his presumption that I was trying to turn around in the parking lot, but my car wasn't parked.
That wraps up this video. I have to admit, I'm a bit rooting for him. He seems young and somewhat capable, and the country could use more thoughtful, contributing citizens instead of people getting tangled in misguided sovereign citizen beliefs. Next, so we move on to a case out of Wisconsin where a self-represented individual had his bond revoked simply because he treated court appearances as optional. Now, he'll face future court dates under much stricter oversight.
So the court is ready to make a decision in this matter. So in regards to the B ticket, that is the equipment violation, basically having obstructed vision with window tint, at this point, the court is finding you not responsible for the window tint, Mr. Smith, because based on just the testimony today, I don't think there's enough established to confirm whether or not the window tint would have been in violation. Now, regarding the A citation, that being the failure to disclose the CPL, the court is finding you responsible in that matter. And that is, again, based on MCL 28.425F. Basically, an individual licensed under this act to carry a concealed pistol and who is carrying a concealed pistol and who is stopped by a peace officer shall immediately disclose to the peace officer that he or she is carrying a pistol concealed upon your person or in your vehicle.
May I add, please?
Well, no, because at this point I'm making my ruling, and the pistol was in the vehicle. I understand it doesn't sound like you were in the vehicle at this point, but you were engaged with the officer, and it was your responsibility as the person with the CPL to immediately disclose that you had a CPL and that there was a weapon in the vehicle. So you are being found responsible. Again, this is a civil infraction for a first offense. There's a fine here of $500, and your license to carry concealed is being suspended for 6 months. Now, what I am going to say is that you do have the right to appeal my decision as the magistrate. If you do so within the next 7 days, the case will be reheard by the judge. So
How do I appeal?
you would have to either consult with an attorney or you can talk to the clerks about getting the paperwork. I cannot give you legal advice. So
Yeah, because I wasn't, as he stated before, sorry, I wasn't actually engaged in a traffic stop. That was the problem.
At this point, the court has made its ruling. This hearing is concluded. I believe that concludes the docket this morning.
It wasn't really against your will, was it? You admitted to ignoring a previous judge's questions, which counts as direct contempt of court. Acting that way in front of a judge is serious and can also lead to bond violations. At this point, you're effectively working against yourself. The smartest move would be to let the public defender handle the case, because trying to navigate it alone is only making things worse.
Call 24 CF 1527, State of Wisconsin versus Gregory Robinson for a bail hearing. Appearances.
ABA Cecilia Martin.
Attorney Stan Woodard, Public Defender's Office, appearing on behalf of Mr. Robinson, who does appear by video from the Dane County Jail.
Why don't you speak on
A copy of the complaint in this matter.
It is a bail hearing. State's position on bail.
Thank you, Your Honor. The state is asking that the court increase cash bail in this case to the amount of $50,000 with all previous conditions to apply. The state is stipulating that any previously posted cash bail could apply to that amount. The defendant have already demonstrated an ability to post some amount of cash bail. He posted $3,000 in this case in late June. He then missed a court appearance. The court set cash bail at $7,500 while applying the previously posted $3,000 in August, and then reduced that amount back down to $3,000, applying the previous amount. So in essence, allowing the defendant's release after the remaining custody, that release was in September. Just 1 month later, he missed court again. He has been out in warrant status for months and had to be extradited here at no small cost from the state. So for this reason, I'm asking all the state's recommendation.
Attorney Woodard.
Objection, Your Honor. I'm pro se in my case, so I don't know why that gentleman is standing there. And I want to speak on my own behalf because I am pro se in this matter.
Hold on 1 second. Hold on 1 second.
Yes, ma'am. Hold on, that's where-
I have no objection, and that's how he wants to proceed. If you're right, just so you know, you do indicate you do not want a public defender, and that's what I happen to be, so I'm happy to withdraw.
If your goal was to do the right thing, you wouldn't have refused the judge's questions. As mentioned earlier, a choosing not to answer is your right, but every choice carries consequences, especially in court. Both sides have now presented their arguments regarding bond. With the case fully heard, the judge is ready to deliver a ruling and determine the next steps.
Mr. Robinson, this is solely about bail. What do you think I should set your bail at here today?
First and foremost, ma'am, I think it should be reinstated to what it originally was.
Hold on. Actually, I want to make sure you're capable of representing yourself, sir. It looks like
Yes, ma'am.
you've done so in the past. How old are you, sir?
I'm 41 years of age, ma'am.
Do you read, write, and understand the English language?
Yes, I do, ma'am.
Have you had any drugs,
And I have
alcohol,
a
or
paralegal degree. Yes,
have you
ma'am.
had any drugs, alcohol, or medications that interfere with your thinking here today?
No, ma'am.
You fully understand everything I've asked you and everything that's going on, sir?
Yes, ma'am.
All right, what do you think I should do in regards to bail here today?
Well, first off, I want to object to what the prosecutor has said. First and foremost, it's only been one time that I allegedly failed to appear. First and foremost, everything that we filed is being pro se, standing in my own prior persona. And the last thing that I filed, ma'am, was a default judgment. And in this matter, the state has
Sir, we're here solely on bail. So what do you think should set your bail on here today? Please stick to the argument.
Well, ma'am, first and foremost, I think it should be reinstated because it's not right what the state is doing. She just sat up in open court and just lied and said I missed court multiple times. This is not true. When I was taken into custody, it's because the first time was because the judge that I went in front of, Mario White, jacked my bond up because I wouldn't answer his question. I refused to answer the questions that he wanted me to answer because it's my right. And I chose to remain silent and not answer what he wanted. So he took me into custody to try to make me do a competency hearing against my will.
You say you want to be out of jail, living your life, but at the same time, you missed court dates, refused to answer the judge's questions, and only participated in this hearing once you were taken into custody. Actions have consequences, and it seems you're exactly where those choices have led you. That's the end of this video. If there are updates, I'll keep you informed. If you enjoyed it, hit like. If not, hit dislike. But don't forget to comment and subscribe with notifications on so you never miss new content.
But in this matter, I feel like my bond should be reinstated. I didn't run. I didn't hide. I exercised my right. I filed my paperwork, and time again, the state has not responded to any of my filings. Had I been a licensed bar member, all of my filings would have been responded to. But since I am pro se in this matter, they have not awarded me or afforded me.
You're only here on bail here, sir. Only here on bail. Stay focused. What you want me to reinstate? Anything else in regards to bail?
I'm asking for my bond to be reinstated to what it originally was. I just lost my sister.
Thank you, sir.
I just lost my sister, December 22nd. I have not had time to go with my family and grieve. I've been in custody since December 12th and I'm currently in custody right now. So I'm asking for you to do the right thing and allow my bond to be reinstated. I did not bail jump. I didn't catch any new charges, ma'am. In this matter, no new charges. I did not catch any new charges. And I'd appreciate it if the state didn't lie and say that I missed court multiple times, because this is not true. And then you're standing in court, in open court, lying under oath. You're a public servant. I'm a
All
civilian.
right, sir, focus. You've made your point, and I do see that you only missed court one time on this case, okay? So please continue. Anything else you want the court to consider in setting your bail?
I want the court to consider that I am pro se. I don't have the college education that she has. I don't have the ability to sit up and lie and try to tarnish her character in open court. I just pray that this court and that you, ma'am, have leniency and respect, and I'm here trying to do the right thing.